Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. The Foreclosure Abuse Prevention Act, or FAPA for short, was effective on December 30th, 2022, and sent shockwaves throughout the New York foreclosure industry by amending numerous laws pertaining to the statute of limitations. It retroactively nullified any unilateral act a mortgagee took to revoke or stop acceleration. Last week, in East Fork Funding LLC v. U.S. Bank, the United States Court of Appeals for the Second Circuit certified the question of whether FAPA can retroactively apply to discontinuances taken prior to its enactment. I'm Adam Friedman, managing partner at Friedman Vartolo, and I'm joined by two attorneys who need no introduction. Friedman Vartolo partner Zachary Gold and senior appellate counsel Stephen Vargas. How's it going, guys?
Doing good.
Great.
Thanks for joining me today.
Very
excited. This is a huge topic. Look, before we jump into FAPA, can you just walk us through the statute of limitations for a mortgage foreclosure action in New York?
Sure. So, generally speaking, the statute of limitations is 6 years from acceleration. And acceleration is when the total debt on a loan becomes due. And in New York, case law has held that is one of the acts of acceleration is the filing of a summons and complaint, where you declare the total amount due. So that starts the clock, the 6-year clock on the statute of limitations. In 2021, the Court of Appeals issued a decision in Engel, which held that the voluntary discontinuance of a foreclosure action serves to automatically deaccelerate the debt. And by that, I mean restore the loan to an installment contract. So instead of the total debt being due, now you the borrower only needs to make monthly payments towards the mortgage.
So the retroactive part of kind of where we are with FAPA is a big deal. But Steve, before we get into that, what did FAPA do?
The FAPA amended a number of statutes, including the CPLR and the RPAPL, which is the Real Property Actions and Proceedings Law, as well as the General Obligations Law. Most of the statutory amendments related to the statute of limitations, as you said initially. Two of the most impactful amendments were the amendments at issue in this case, CPLR 203H, which is actually a new statute, and CPLR 3217E, also a new statute. These are referred to as the, quote, anti-Engel amendments because they were written in direct response to the Freedom Mortgage versus Engel high appellate court decision that Zach mentioned, in which the court held that a voluntary discontinuance of a foreclosure within 6 years of its inception acts to revoke the acceleration and return the loan to installment status. So FAPA, with these two statutes in particular, sought to overrule Engel and prevent the lender, assignee, loan servicer, note holder from taking any action to unilaterally revoke the acceleration. Now, specifically, 203H says that a lender cannot unilaterally reset or annul or reset the statute of limitations. 3217E pertains specifically to a voluntary discontinuance and says that a lender cannot unilaterally revoke an acceleration through a voluntary discontinuance.
So we're saying FAPA impacted a mortgage holder's ability to voluntarily discontinue the case and then revoke the acceleration?
The bank would still be free to discontinue a case whenever it so chooses, provided the court granted, let's say, a motion or the bank timely filed a notice to discontinue. What it did was, with respect to 3217E, created a new law that provided if an action is discontinued, even if it's done within 6 years from acceleration, that has no effect on the statute of limitations or the acceleration of the loan. So the action would be discontinued, but the acceleration that was initiated when the complaint was filed would remain in effect and immaterial of whether the action was discontinued or not. So you had commencement accelerating. The discontinuance would terminate the case, but the acceleration would remain in effect. And the SOL would continue to run on the accelerated debt.
Right, so going back to Zach's point, the 6 years is still running. We're
Correct.
Not getting another 6
Exactly.
years.
What that would mean is you'd have to commence a new case within the 6 year period from when the first was brought.
And if we were beyond 6 years,
Exactly. If you discontinued an action outside the statute of limitations, even under pre-Engel law, the Engel case law, that wouldn't allow you to reset the SOL because it would be done with outside the limitations period. But certainly now, if you discontinued an action in a post-FAPA world, more than 6 years from acceleration, you've time barred your own loan.
And Zach, we're talking about the word unilateral. Can you just explain what that means?
Sure. I can give a better example of what is not unilateral. So an agreement between the parties, let's say a loan modification agreement or a reinstatement agreement that brings the loan current, that would be not a unilateral. That would be a joint act, a joint understanding that the loan is being deaccelerated. A stipulation, any form of agreement between the two parties. Unilateral would be something where a lender sends a letter saying, hey, your loan has been deaccelerated and we're restoring your loan to an installment contract. That's a common example of a unilateral deacceleration that we would see back in the day.
Okay, so to be clear, if both parties sign something saying we're discontinuing, we're set, it doesn't really matter, right? Yeah. If they both sign something, that can revoke acceleration.
Correct.
If the plaintiff sends something unilaterally, hence the term, it does not.
Right.
What if plaintiff can plaintiff file something and the judge issue an order saying acceleration is revoked?
Not post FAPA. What we would often see is plaintiff's counsel would make a motion before the court and it would go unopposed saying we're discontinuing the action. And in that order, they would add language saying the loan is hereby deaccelerated, asking the judge to sign off on that order. That would be an example of a unilateral deacceleration that FAPA now precludes.
Okay, so now, look, you guys done a great job laying out what's going on here with FAPA. Let's now focus on the retroactivity part a little bit. It doesn't sound great when a court is changing laws or a legislator changing laws that impact things that were completed prior to that law's enactment.
Right.
But I know in this issue, this is especially troublesome. Can you give the viewers some examples of why this is causing so many problems?
Sure. Broadly speaking, we as lawyers and our clients rely on the law as it exists to govern our behavior. So when we make business decisions on loans to purchase, when we make legal recommendations on how to handle a case, we rely on the law as it exists. We can't anticipate what a law is going to be in the future. So by making something retroactive, it's fundamentally unfair, and it can create a whole slew of problems. I could give you an illustration of that. Just as one example, let's say one of our foreclosure cases gets dismissed, and we have to make a recommendation to our client. What do you want to do? Do you want to appeal this decision? Do you want to re-argue? Do you want to just try to restart an action? And part of that calculation is knowing what the statute of limitations is. So we will forego an appeal of an improper decision because we'll say, hey, you can just recommence, you're within the law as it exists. But if you change the law and then make it retroactive, it messes up everything.
I mean, that's huge. So you're saying yourself, other people, right, different attorneys in this industry, it's honestly, it sounds very likely that prior to FAPA's enactment, they're recommending to a client to not appeal a bad decision and to restart, thinking they still had enough time. But now, when this is passed in 2022, they learn that was the wrong decision.
Absolutely, because when you decide to take an appeal, there's 2 or 3 years till you get a decision. There's costs. There's uncertainty. But we would certainly take that appeal if we knew that there was any risk of the loan being completely wiped out. And FAPA created that problem, where we have several cases where we've made legal recommendations that are now not good law. And conversely, our clients have made business decisions based on what they determine to be low risk or viable assets that are now no longer viable.
Crazy situation. All right, so now let's move into East Fork. So what are the facts in East Fork, the U.S. Bank?
Yeah. So the facts in East Fork are, it actually involves 3 state foreclosure actions. So the first one's commenced in 2010, and that one gets voluntarily discontinued in 2011. And then there's a second one in 11 that gets discontinued in also 2011. The third foreclosure action gets commenced in 2016, and that one results in a judgment for the bank in 2019. That judgment subsequently gets amended on a later date. But while that third foreclosure action is pending, this entity known as East Fork, which to many of you will be an entity you're familiar with because they are serial litigants. The gentleman behind the company is a very famous litigant whose modus operandi is to purchase deeds on the cheap, and often in condo foreclosure actions, as was the case here. And then this individual, through various corporate names, will then seek to challenge the bank's mortgage and seek to have it extinguished based on a technicality, usually related to the statute of limitations. So that was the case here, where East Fork commenced a quiet title action in federal court. And a quiet title action, for those that don't know, is basically an action seeking to declare the rights of the litigant, and in this case, to have the mortgage on the property declared time-barred and expunged. So East Fork commences this action in federal district court, and they get summary judgment because after they commence the action, FAPA gets passed, which is case law that actually changed the law and helped them be successful. So it held that, as we discussed, that a voluntary discontinuance did not serve to deaccelerate the debt. So they argued that as a result, the mortgage was time barred, and the district court agreed with them and granted them summary judgment. And then the Court of Appeals certified, the Federal Court of Appeals certified the question, which we will now discuss, to the Court of Appeals in New York.
Steve, it's been 2 years, or roughly 2 years, since FAPA was enacted. And clearly the retroactivity part of it is a big deal. So why did it take this long for a higher court or for a court to question the retroactive application of FAPA?
Most of the litigation regarding FAPA, the vast majority, has occurred in the state courts. The state appellate courts, for a variety of reasons, mostly procedural grounds, have not considered the constitutionality of FAPA. In most of those instances, the briefing in the appellate court was done before FAPA became law. So the briefs themselves didn't address FAPA. Thus, the plaintiff or the mortgagee in those cases did not raise an issue of whether FAPA applied retroactively or not, or whether FAPA as applied retroactively would be constitutional. There was no briefing on it. Some appellate courts allowed supplemental briefs to be filed. What happened was, if the plaintiffs put in supplemental briefs or in the regular briefs actually were able to brief the FAPA issues because the briefs were filed after FAPA became effective, then the courts would typically the appellate courts would remand the appeals back to the trial court for further consideration in the event the trial court had not considered FAPA. In the instances where the trial courts had considered FAPA, so trial court litigation that occurred after December 30th, 2022, the appeals taken in those cases are pending before the appellate court. We haven't had a decision. So it's mostly due to appellate timelines and certain procedural issues regarding whether the issue was raised by the parties. That's why we haven't seen it addressed by the state appellate courts yet. There's very little mortgage foreclosure related litigation that goes on in the federal appellate courts. This is the United States Court of Appeals for the Second Circuit. So why we haven't seen it out of an appellate court yet is because parties sparingly litigate mortgage foreclosure litigation or quiet title actions in the federal courts. That's why this is, like I said, more than 20 months, the first time a federal appellate court has issued any sort of decision on the issue, and why to this point we have not seen a single state appellate court rule on whether FAPA is constitutional if it applies retroactively.
Okay. And just for the audience, what are the legal issues here? What are the legal issues that are presented in this case?
There was a very specific question certified by the federal appellate court to the New York Court of Appeals. They specifically required the Court of Appeals to decide whether FAPA's CPLR 203H and CPLR 3217E were taken as part of omnibus FAPA. Did they apply retroactively to the prior discontinuances taken before FAPA's enactment? If so, is the retroactive application of FAPA constitutional? That's the big question that was presented. So the federal appellate court sent a question to the state appellate court and asked the state appellate court to make a decision, the state's highest appellate court, the Court of Appeals, to actually decide whether FAPA is retroactive, and if it's retroactive, to what extent it's retroactive. So, and that's a big distinction there. Retroactive general means it could apply two different ways. It could apply to a case commenced before its effective date. Under that scenario, an example would be action commenced in 2021. FAPA becomes effective December 30th, 2022. if it's applied retroactively to that particular case, a discontinuance taken in that case after FAPA's enactment would not unilaterally revoke the acceleration. The other retroactivity that's more problematic is if it's effectively indefinitely retroactive, meaning it applies to prior actions that terminated before FAPA became law. And based on the timeline Zach discussed, we're talking about a situation where for FAPA to apply to this particular case, this fact pattern, it would have to apply to actions commenced and discontinued more than a decade ago. So the federal appellate court is saying, A, is it retroactive at all? B, what's the extent of the retroactivity? That's the scope of the question certified to the Court of Appeals. The federal appellate court gave the Court of Appeals some additional latitude to opine on any other relevant issue that may be necessary to decide the question. Interestingly, the federal appellate court said, regardless of what the Court of Appeals says, we reserve the right to determine whether the retroactivity is actually constitutional. So in the end, the Court of Appeals in New York, the highest appellate court, will give you an opinion on whether it's retroactive, the extent of the retroactivity of these statutes. But the Court of Appeals may or may not get into the constitutional question, and the federal appellate court definitively will get into that question.
I just have a follow-up question on that. If they analyze the retroactivity of FAPA,
The Court of Appeals?
The Court of Appeals, do you see them discussing retroactivity in general or limiting the retroactivity analysis to just voluntary discontinuance issues?
I think there's a distinct possibility that the discussion will be more broad than simply 3217E and 203H. So I think there's some legitimate potential for the Court of Appeals to say, FAPA amended 8 different statutes. This is the first opportunity we have to address FAPA at all, as far as retroactivity is concerned. So we're going to address these specifically because the question was certified to us that we have to address these. But tangentially, at a minimum, I think they'll address some of the other statutes or say the retroactivity is similar across the board with FAPA, or they may say it's specific to each amendment. So each statute is a specific, each statutory amendment addressed a particular section of the CPLR or the RPAPL or the GOL. So it's possible that they will say this statute applies retroactively and statute B does not apply retroactively.
So the initial foreclosure actions were in state court. How are we involving federal courts?
That is correct. The 3 actions were all in New York State court. We're in federal court because East Fork commenced this quiet title action for whatever reason in federal court. They were allowed to, but for some reason they elected to commence it in federal court. Ostensibly because they thought they would get a quicker decision in federal court.
Is that common?
It's not uncommon. It's not uncommon. So it's really an election of venues by the litigant. They can commence in either federal court or state court.
It's really relying on the diversity jurisdiction statute. So in most instances, actions like Zach said, most of these cases, foreclosure and quiet title are commenced in the state courts. But the diversity jurisdiction statute in the U.S. Code allows plaintiff who's a citizen, defined by case law, of state A to sue a citizen of any state other than state A in the federal district court, provided the amount in controversy at issue exceeds $75,000. In this case, the basis of the action was the corporate LLC plaintiff is a citizen of state A, U.S. Bank is a citizen of state B, diversity exists, diversity of citizenship exists, and the amount in controversy is based on the property value, mortgage balance, far exceeds $75,000, and that's what East Fork relied on to bring the case.
But to answer your original question, it would be more common for them to have commenced in state court as opposed to federal.
Okay, guys. So what are our predictions? How do we see this case wrapping up?
Hard to say. I would anticipate that the Court of Appeals will determine that retroactively applying FAPA in this instance was unconstitutional. But they did open the door to make it as broad as the court wanted it to be. So it is possible that we could see them addressing issues beyond just, CPLR 2317. Because as we discussed, FAPA amended a whole series of laws surrounding the statute of limitations. So we really don't know the scope of this decision.
Steve, what do you think?
I'm not going to maybe make a prediction on the actual conclusion as far as the constitutionality of the retroactivity. What I will say is, obviously, at a minimum, they will decide the extent of retroactivity. And like Zach mentioned, the certification question gave the Court of Appeals authority or the opportunity to opine on a broader perspective of FAPA. And I think the litigants in the case, the Attorney General, which intervened in the case in support of the constitutionality, as well as what I anticipate being numerous amici, these interested parties, interested non-parties who are going to file briefs in the case, I think all of them will urge that they will urge the Court of Appeals to give some sort of opinion on the constitutionality and the retroactivity. So I really do think there's so many parties that are going to want conclusion to address that. I think they're going to want to just get some closure on this issue. And I think that's going to be helpful because everyone's going to urge the court to decide on the retroactivity issue. We don't want to deal with this anymore. We want to have closure on this issue.
But I think it's important to highlight that a resolution to this decision may not foreclose other avenues of attack to FAPA. Like there could be different fact patterns and different bases for challenge beyond this decision. I think of, for instance, the issue of when is a judgment enforced. So the cutoff period for making a FAPA challenge per the statute is supposed to be up until judgment is enforced. And I could see that being an issue that gets litigated. So, you've had a judgment since 2015. I think this was 2019. Was that judgment enforced? Did they file and serve a notice of sale? Did they schedule a sale and then it was stopped last second because of a bankruptcy?
So we'll be doing more videos, it sounds like.
Yeah, we're going to be doing lots more videos. And there are other issues discussed even in the concurrence opinion about the principle of a judgment being final. And that's supposed to resolve all litigation, regardless of a change in law, and how that triggers principles of res judicata. You're supposed to honor that judgment, regardless of if there's been a change of law. And that's basically what happened here, 2019 judgment. And then FAPA gets passed, 3 years later, and you're going to apply FAPA to a judgment from 2019. Right. And there's a whole other issues, like, I don't know if the court will get into, whether that judgment constituted a property right.
I think it benefits all parties in foreclosures, the borrowers, the homeowners, and the mortgagees, for the Court of Appeals to give as broad of an opinion as possible. Obviously, the federal appellate court, in this case, has the final say. The constitutional issue aside, they'll apply the state laws the Court of Appeals interprets, but they may rule differently on the constitutional issue. But I think because, like you mentioned at the beginning, it's been 20-plus months. We have no New York Intermediate Appellate decisions on the constitutionality. We haven't really, even the appellate courts have simply said it applies retroactively. They haven't gotten into why. They haven't actually gotten into a statutory interpretation analysis. But I think the bottom line is the Court of Appeals is probably aware there are hundreds of appeals pending in their state that they haven't had an opportunity to hear for a variety of reasons. And this is their opportunity to opine on an issue that impacts thousands of foreclosures statewide. It would benefit everyone for them to give a super broad opinion on this.
That's a very good point. So there is a policy of the Court of Appeals to try to issue a bright line rule. They don't want to continue to have like these multiple attacks where people are trying to distinguish based on sort of nuances in each individual case. They want to create a rule that will govern all facts. So to Steve's point, yeah. Yeah,
it's been years. It could be years. If not for this certification from the federal appellate court to the Court of Appeals, we don't know when the Court of Appeals would have actually opined on this. This opinion should be issued next year. We anticipate maybe, my opinion will be second, third quarter of next year. If not for this, it could take the Court of Appeals another year beyond that to actually weigh in on the FAPA retroactivity and constitutionality, and that just delays any sort of finality for all litigants. And like Zach mentioned, attorneys make strategy recommendations based on the law as they know it. Clients on both sides of the V decide what to do with cases, whether it's settlement or litigation, based on the law as they understand it. Finality and closure on these issues, retroactivity and constitutionality, are going to be essential for anyone to actually make a legitimately informed opinion rather than the speculation we're currently dealing with.
That makes a lot of sense. Yeah, look, it's obviously a huge issue. This was really helpful, though. And again, as I kind of said, I'm sure we'll be back here for more videos.
Of course.
Thanks for joining Zach Gold, Stephen Vargas, and I on the Weekly Friedman, your source for the most essential information in the default industry. We appreciate you guys watching. Thanks for tuning in, and we'll see you next time.